Hello, I'm Dave Evelyn, and welcome to Closing Court. This is the case of time after time. The plaintiff, who says that her new car salesperson failed to properly negotiate the sale and close of a new car, is suing for her time and trouble. The defendant says that, if anything, he is the injured party, since he lost not only a sale and its commission, but also the opportunity to close another prospect while engaged in negotiations with the plaintiff. Well, Judge Lobner definitely understands that time is money, and he knows the law. So let's watch now as he hears the testimony in this dispute.
I know you've been sworn and I've read your complaint. Now, Miss Bradley, tell me what happened between you and Mr. Patterson.
Well, sir, he showed me the car and we took a demo ride, and I was ready to buy. But then when we got back to his office, I wanted to talk about some options, and that's when it started.
What started?
His incompetence. I mean, he really didn't help me decide what options I needed on my car.
Did you help her select options?
Yes, Your Honor. I looked up the price for every option she mentioned. She was so opinionated.
You'll have your chance to testify in just a moment. Did he look up the prices for you?
Yes, he did, but he really didn't help me decide what should go on the car and what shouldn't.
Do you expect that kind of advice from a salesperson?
From a good salesman, yes. I mean, you have to know how much you can load up the car without going over your budget. And you have to know what trade-offs you can make.
I see. So he looked up the prices, but didn't take the time or the interest to advise you on your option choices. Is that correct?
Yes, Your Honor.
Then what happened?
Well, we started talking money, and he gave me a price that wasn't right.
Could you explain what you mean?
He gave me a price on the new car that was really low. Almost $1,500 off sticker.
Well, what's wrong with that?
Well, it looked like a good deal, but it was a false quote. He didn't include taxes, license, title fees, and so on. And it turned out that what he took off the sticker price was going to be partly made up by the very low trade-in allowance he gave me on my old car.
How do you respond to that, Mr. Patterson?
Well, she started off demanding my very best price. So I quoted her a figure I knew my sales manager would buy. And I explained how we couldn't give as much off her old car.
So there never really was a meeting of the minds on this issue?
No, sir.
Ms. Bradley, did he show you the costs?
Not really. And when it became obvious that we were just too far apart, he called in his sales manager, and at first I thought that that was going to help. But I soon realized that they were playing a good guy, bad guy game with me, and I didn't think that was fair.
Now, we're not interested in your opinions here, just the facts. Well, what's your side of the story?
Ms. Bradley came in wanting a very good deal. She admitted shopping other dealerships, so I presented a car, and we went for a demo drive. When we got back to the office, we picked out the options she wanted for her car, and when I totaled them up and showed her the price, she seemed to think it was okay.
Did you?
Well, yes, it was a great price, but then he wouldn't give me what my old car was worth, and so the difference was just too big.
Well, Your Honor, you can't have a super price on both ends. We just wouldn't make any money.
So the disagreement centered on the trade-in allowance and the difference price, is that right?
Yes, sir. I could see I wasn't getting anywhere, so I suggested my sales manager join us.
Now, just a minute. At any time before this, did you go over the costs with Miss Bradley, item by item?
Well, no, sir. She was hung up on the difference. And I wanted my sales manager to explain to her why we couldn't give her as much for her old car.
Yes, but did you explain about the other charges, the dealer prep and destination sales tax, and all those things?
Yeah, I guess so.
You guess so?
Well, she gave me a hard time on the trade-in, and I was trying to handle that. Frankly, Your Honor, the car was a dog. I mean, it had rust holes in it the size of...
That's not the issue here. Now, what happened next?
Well, the three of us discussed alternate ways of closing the deal. We mentioned a larger down payment, bigger monthly payments, or different terms, a 60-month loan instead of 48.
Is that what you did?
Yes, but I couldn't handle a bigger down payment or monthly payment. And the longer loan payment required such high interest charges that the total cost of the car was just ridiculous.
And you weren't willing to compromise in any of these areas?
Yes, I was willing to compromise a little, but I felt their figures were just too far off what I could afford.
So there was no deal? Was a purchase agreement written?
Yes, Your Honor, I did prepare a purchase order, subject to a reappraisal of Mrs. Bradley's trade-in, but it was never signed.
Your Honor, I never signed it because he never explained it to me. He just said that they'd have their sales manager take another look at my old car.
And how much time was spent in these negotiations?
About an hour, but I'd say total time on the sale more than 2 hours. I did everything I could. I gave her the option prices. I brought in my sales manager, and we talked about different ways to put the sale together. She just wasn't flexible.
That's not exactly true, Your Honor. I was willing to pay more, but I just felt he didn't do his job right. He didn't advise and counsel me the way I felt he should, and he didn't explain things thoroughly.
Well, I'm going to take a brief recess, and I'll come back and give you my decision.
This case has proved to be very interesting for the observers here in the courtroom. They are split almost down the middle as to how they would handle the case if they were the judge. Half of them would rule for the plaintiff, saying that she was not advised properly during the negotiation and closing, and the other half saying that since she was inflexible, they would find for the defendant. Well, that's what the observers think. Let's find out now what Judge Lobner thinks.
The legal principle involved in this issue is that of reasonable expectations consistent with common practice within the profession. Now, since we have no testimony from expert witnesses or observers, my findings will be based on the evidence. Now, Miss Bradley, it appears that you were trying to drive a very hard bargain. A bargain so hard, in fact, that the dealership couldn't accommodate it. Now, there's no penalty in that. This is every consumer's right. But on the other hand, Mr. Patterson, you also failed in fulfilling Miss Bradley's expectations. You failed to explain to her fully, precisely, and in detail the costs, although it does seem that you did make a good faith effort in presenting alternatives. So what this comes down to is what is consistent practice in the industry. Now, from my experiences buying cars and from my knowledge of other people's experiences, I would have to say that this case is not uncommon, unfortunately. Only the very best salespeople provide the kind of professional advice and thoroughness that you were expecting, Miss Bradley. And while Mr. Patterson's performance didn't live up to your hopes, it nevertheless was no worse than average. In the end, what resulted was a great deal of loss of time for both parties. However, the court does feel that justice has been served in that Mr. Patterson lost the sale, and certainly that is punishment enough. So, my decision in the case is to dismiss the suit against Mr. Patterson and to also dismiss the countersuit against Miss Bradley. I hope that you've both learned something from this.
So, a surprise judgment dismissing both cases. This is Dave Evelyn thanking you for joining us and reminding you that if you're engaged in negotiations with another party and you just can't reach an agreement, don't give up and don't despair. Just find a better salesperson.